Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
You're gonna.
Are you waiving the repeat enhancement
Sorry.
allegations?
Yes, Your Honor. We are waiving and abandoning the repeat offender allegations.
Any objection?
No objection.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, off the record. My understanding is that you're requesting it to be sentenced on a different day. Is that correct?
Yes, ma'am. if that's
All right.
possible.
Do you understand that if you don't show up for sentencing, you're going to be subject to the full range of punishment?
Yes, ma'am. I
And
do.
that includes the enhancements. Did you understand that?
Yes, ma'am.
All right, you want to write that in your agreement? Yes, other. And on other, you just put that if the defendant fails to appear on Thursday at 9 a.m. And that's Thursday, August 3rd. So if the defendant fails to appear on Thursday, August 3rd, 2023 at 9 a.m., he's subject to the full range of a punishment, which includes the repeated enhancement allegation.
Don't disclose that.
Mm. Yes, ma'am.
Okay. Why do you say that?
Oh, they need to sign it.
Can we just put initials, Judge?
If you want to put initials, you can, and your client must also.
That's right. Right.
All right. Did you understand and review the document entitled Court Admonishments with your attorney? And did you sign it in all the appropriate places?
Yes, ma'am.
Understand that you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the state jail facility. There are no applications. If you fail to appear on Thursday, August 3rd, 2023 at 9 a.m., you will be subject to the full range of punishment, including the repeat offender enhancement allegations. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Francis.
To the enhancement allegations, how do you plead? True or not true?
What, Judge, they waived the enhancements.
They are, but he's going to be subject to the full range of punishment if he does not show. So in order to do that, I need to have documentation that the enhancements are actually true. Of course, if he shows up to court, guess what? It doesn't matter that you pled true to the enhancements.
What do you want to do?
I'm gonna show up, so I won't agree to it.
I'm sorry.
I'm not gonna agree to it. 'Cause I'm gonna show up on Thursday.
All right. Well, you're scheduled for jury trial. Just a minute. Just have a seat. We'll take you up for trial after we finish with these other
No,
cases.
Judge, he wants the deal.
Oh, you want to do
Yes,
it?
ma'am. Yes,
Oh, I'm sorry.
I advised him not to take the deal under your conditions, but he wants to take it anyway.
All right. Then to the allegations, the repeat offense offender enhancement allegations, how do you plea? True or not true?
True.
All right. State any evidence to support the defendant's plea.
Your Honor, I submit State's Exhibit 1 in the attachments.
No objection.
Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it?
Yes,
And
ma'am.
did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. We'll be back on August 3rd for your sentencing date. Do you understand?
Yes, Your Honor. Thank you.
All right, you're welcome.
Thank you.
Okay, and if, sir, we're off the record, sir. I understand what the charges are in here, and I read the police report. Between now and then,
Yes, ma'am.
do not use,
Yes, ma'am.
you can still get help.
Yes,
Go
ma'am.
to a sober meeting, go see where you can get help. You understand?
Yes, ma'am.
All right, Ms. Ferguson will give you a reset form.
All right. Thank you, Judge.
You're welcome. Michael Kilgore. Probation, this is an application. You're on a pleading on one case?
Yes.
Court is calling 2022 CR 6781 State of Texas versus Michael Lee Kilgore. Can I have parties announced for the record for the state
Ruben Herrera for state.
defense?
Adeline Silver for the defense.
And are you Mr. Kilgore?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Kilgore, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state is waiving counts 1 and 2 and proceeding as to the lesser included charge of assault, bodily injury, married cohabitation, and count 3.
Any objection?
No objection.
Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation? That is a class A misdemeanor. The range of punishment is anywhere up to $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Kilgore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation under count 3. State recommends deferred adjudication. They're taking in consideration 2022 CR 7213. There's an affirmative finding of family violence, and there's to be no contact with Sherry, Sherry, Garman, Garman. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, Your Honor.
defense,
Yes, Your Honor.
showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 2 years in the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all of its attachments.
No objections, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, and have you spoken to the complainant?
We have, Your Honor, and she has been cooperative throughout this. We have let her know of our plea offer that was tendered to defense counsel, and she was on board with that offer.
All right. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, he's ready for a fresh start and in terms of if he is granted deferred adjudication, he would ask that his deferred adjudication be able to move with him in his new place that he plans on residing in, which is in another state.
And what state is this?
Indiana,
What city?
Indianapolis.
What county?
I'm not sure. Indianapolis.
Who do you know there?
No, my girl's there. She works for the NCAA. So that's the
Who is
main
your
one.
girl?
Diamond Chestnut.
No, I mean, what is her relationship? You say girl, but what does that mean?
Like she's my girlfriend.
And is she aware of your history?
Yeah, we've been together. We've known each other since high school, since freshman year. So
All right.
Yeah.
But does she know about this case?
yeah, of course.
Well, you say of course, but many times that's not the case.
Yes, Your Honor, she does know. I have been in communication with her regarding this case.
So she knows that he beat up another female
Correct, Your Honor.
and she still wants to be with him.
Correct, Your Honor.
I guess there are limited men available. Do you have any children?
Yes, I do.
What are their ages?
2-year-old, I got a 3-year-old, I got a 5-year-old, I got an 8-year-old, a 7-year-old, and I got a 6-month-old.
All right. What's the date of birth of the 6-month-old?
I can't tell you right now.
What's the date of birth of the 7-year-old?
8/28, 2015. I got a
The 8-year-old, what's the date of birth?
2014, April 25th.
5-year-old.
I don't know that one.
All right. Why would you use profanity and say the S word and then you don't know that one? What's the date of birth of the 3-year-old?
Can't tell you, I wasn't there.
What's the date of birth of the
I
2-year-old?
wasn't there. That's not their my kids.
I'm sorry, what?
I said I couldn't tell you I wasn't there. That's not their minds. I had DNA tests for them, so
So you mean those are your children?
yes, they are.
All right. When's the last time you had employment?
No, I have my own business, so
So doing what?
car dealership.
So do you have a car dealership in Indiana?
I have a master bidder license that's registered to the Texas Sub Controller in San Antonio, Texas.
So you don't have a business in Indiana?
No, my business still will be here. So
All right. And do either of these children, is their mother the complainant in this case?
no,
And I'm sorry, how old did you say you were?
I'm 27.
You're 27. You should not be dating 18-year-olds.
No,
I know 18-year-olds are legal under the law, but what is a 27-year-old doing with an 18-year-old? And when she was working at Jack in the Box, what employment did you have?
I still had a car dealership, so
And were you selling any vehicles?
yes, I was.
Who were you living with?
No, I live by myself. I have my own place.
All right. Any other questions?
Nothing based on that, Your Honor.
Nothing from defense, Your Honor.
All right. The court is going to sentence you to 2 years deferred adjudication. I don't know. Does he need parenting classes or need to stop being fruitful and multiplying? I don't know. But if you have children, you need to take care of your children. And taking care of your children is more than dropping money off to them for a few seconds.
No, I'm
You
advocating all my
cannot.
kids.
No, you don't. You don't even know their date of birth. Like you don't even know when to send gifts to the 2-year-old for their birthday because you don't know when they were born. You don't know when the 3-year-old was born. You don't know when the 5-year-old was born. You sort of think maybe the 7-year-old, maybe that's their date of birth, and the 6-month-old, maybe that's their date of birth, but you really don't know when their dates of birth are. And do they have the same mothers?
No,
How many mothers are we talking about? So you have 1, 2, 3, 4, 5, 6 children, and they all have different mothers.
yes. Mhm.
And so have those children even seen each other?
Yes, they have.
Do they even recognize themselves as their siblings?
Yes.
I highly doubt that. Here's the thing, when you start having children all over creation and they don't know that these are their siblings, for all you know, they could end up dating one of their siblings. And the reason why they don't know is because their father's just having children all over the planet. All right, 2 years deferred adjudication, the BIPP course. There's going to be regular reporting to probation by Zoom or in person. There's to be regular UAs. There's to be no contact with Sherry Garman. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Field visits. Do random one time every 3 months. Take in consideration 2022 CR 7213. Probation, is there anything else he needs? Anything else you need from the court to be successful?
No.
All right. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes,
And
ma'am.
did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And the court is not allowing transfer to Indiana. All right, is there anything else from either side?
Nothing from the state, Your Honor.
And here, to be successful in probation, communication is key. You need to make sure you stay in contact with your probation officer. If you feel that they're not addressing that issue, you can always come before the court, and the court will see what the issue is and address it. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, Your Honor.
All right, Mr. Casablanca, if you'll come forward. All right, Mr. Casablanca, did you have a chance to speak with Mr. Mauer?
Oh, yes, ma'am.
All right, so you know what's going to take place. And you know you're going to have to report to this court twice a month. And they've given you the exact time to report.
We're gonna go over that.
All right, she's going to go over that with you. And you're going to have community service hours to do. You understand?
Yes.
If you fail at any of this or do not follow through on the court's instruction, what's going to end up happening is I'm going to receive a violation report. You understand?
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
You know what you're supposed to do?
Yes, ma'am.
All right, is there anything else? All right, thank you for your military service.
Yes, ma'am.
Yeah, Casablanca. Matthew Avalos. Probation, there's no application. Court is calling 2023 CR 5592, State of Texas versus Matthew Avalos. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
James Hunt.
Is this going to be taken in consideration?
Yes, Judge.
Okay. Yeah, you want to check that off? Are you Mr. Matthew Avalos?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Avalos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I did.
I'm sorry, not the True Bill of Indictment. There's a lot going on in the box over there. Did you review the True Bill of Indictment with your attorney and did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Avalos, by indictment, you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Sure.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Do.
Mr. Avalos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 3 years in the prison. State will take in consideration 2023 CR 5593. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes,
And
Your
did you sign it in both places?
Honor.
Did you understand by signing that you're waiving your right to appeal The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I do.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence
Your Honor, I submit State's Exhibit 1 in the attachments.
showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If you would like to.
Anything you wish to say on behalf of your client?
We believe the plea bargain is appropriate.
Mr. Avalos, who is Crystal Avalos to you?
She's my sister.
All right. And who is Sarah Flores?
She's my friend.
All right. And with your sister, are you older or younger?
I'm her older brother, yes.
Okay. All right. The court will find you guilty, sentence you to 3 years in prison, take in consideration 2023 CR 5593, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. You are the older brother. You're supposed to be looking out for your sister. Looking out for your sister is not having heroin in the car. You understand?
Yes, ma'am, I do.
And the fact that you were trying to swallow it, guess what? If it would have ruptured or something would have went wrong, then your sister would have saw you having a overdose on the street. You understand?
Yes, ma'am, I do.
Do you have children?
No, ma'am.
All right, that's a good thing because you need to work on yourself. If you have a drug problem or an alcohol problem, there are plenty of places that can help you for free. You understand?
Yes, ma'am, I do.
And did that center neck tattoo hurt?
Yes.
And you didn't think to stop here, just I've started, I got to finish.
Yeah.
All right, good luck to you. Okay, take care of yourself.
Thank you, Your Honor.
Who's here on Gavina Var?
We're present, Judge. We're ready.
Court is calling 2019 CR 11408, State of Texas versus Gavina Var. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
John Kuntz and Megan Enriquez for Mr. Vara.
And are you Mr. Var?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review that with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Var, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Var, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of murder? The range of punishment for that offense is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes, ma'am.
If the state proves the enhancement allegation true, then that means your range of punishment will be anywhere from 15 years to 99 years or life in prison and still up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Very much so.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He certainly has both.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Varro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you are to agree that you've been previously convicted of a felony for enhancement. Punishment is be assessed at 24 years in the prison. There's an affirmative finding of deadly weapon and there's no applications. Did you understand that?
Yes.
State,
Yes, Your Honor.
defense?
Yes, Judge.
See, my eyes went different ways. Just tested everybody.
Yeah.
Well, the last time you were here, it was in a different capacity.
That's correct, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it? And did you sign it in both places? Sir, did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal?
Yes,
The
ma'am.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Sorry, just one moment. And counsel, have there been any such motions?
No, Your Honor.
Then as to the offense, in the indictment, how do you plead? Guilty, not guilty, or no contest?
Contest.
And as, which has enhancement are you all proceeding on?
We'll proceed on the second one, Your Honor.
And with regards to the second enhancement, which states, and it is further presented in and to said court that before the commission of the offense alleged above on the 16th day of August, AD 2010, and cause number 2009 CR 10382 in Bear County, Texas, the defendant was convicted of the felony of possession with intent to deliver a controlled substance. Penalty group 1, 4 grams to 200 grams. How do you plead? Guilty? I'm sorry, true or not true?
True.
State any evidence to support the defendants, please.
Yes, Your Honor. State exhibit number 1 with all attachments.
We review them and have no objections, Your Honor.
Mr. Vire, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
And state, is the complainant aware of this plea? The complainant's family at least.
Your Honor, yes, and I mean, they haven't been contacted today, but they're aware of the plea negotiations ongoing.
All right. right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, first of all, we would like for the court to accept the plea bargain and sentence him today to the 24 years. We would also request that he get credit for the time that he has served. He currently has, I think, 275 days in custody. My client has also asked me to ask you if it would be possible to give him credit for the time that he's been on the leg monitor, including on home confinement for a long time. So any additional credit that you could give him would be greatly appreciated. We're very grateful to the prosecutor to come to this number, and we appreciate Mr. Gonzalez's help in getting this done.
All right. The court has read the police report, and I see there were extenuating circumstances all around involving this. So normally I do not allow people to enter pleas on the day of trial, but after reviewing the police report and hearing arguments from both sides and also having discussions with the state in the course in the presence of the defense counsel, I'm going to accept the plea and I'm going to find you guilty. The enhancement is true, sentence you to 24 years in the prison, give you credit for any time served, and there's an affirmative finding of deadly weapon. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're going to have to make better choices. How old are you?
2055.
All right. You know, a gun is not the answer for every argument, every disagreement. Even sometimes I understand that someone was fighting your girlfriend. I read all of that in the police report. I say that because I want you to know that I actually did read the entire police report. Sometimes people say she read that too fast. She didn't read everything, but I do make sure I read everything to make sure that if there is an agreement that's reached, it's an agreement that I think is appropriate. All right. Good luck to you. Okay.
Thank you,
welcome.
Judge.
You're welcome.
Judge, real fast before he's taken, you gave him credit for the jail time, but
Yes.
not for his street time.
No.
Okay.
All right. Could I see the file? Who's here on Manuel Mendoza? All right, we're headed to jury trial.
Judge C is considered dismissal on this. We've been trying to reach out.
Okay. All right, counsel, do you want to put on the record that you tried to get in touch with the complainant?
Yes, Judge.
We're going to go on the record in 2023 CR 2570A, State of Texas versus Manuel Mendoza. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Anthony Cantrell for Mr. Mendoza.
All right, the court called this case for trial today. The plea deadline has expired and the state has decided to tender a motion for dismissal. State?
Judge, so we have attempted to reach out to the complainant using the phone numbers that were in the police report. When those didn't work, we attempted to run another search to get other contact information. When we ran that search, it was the same numbers, and so we were unable to connect.
All right, the court will sign the motion to dismiss. We can go off the record. Mr. Mendoza, the only thing I know about your case is what you're charged with. The only way I would learn more about this case is if it were in trial or someone asked me to read a police report. You know what your actions were that day. I do not. But this is what I do know. Receiving this dismissal is no cause for celebration on your part. Whatever brought you here, you had better start doing things differently. You understand?
Thank you.
You're welcome. Yes. Could I see the file on John Marino? Who's the prosecutor on John Marino? All right. Where's your client? Come up, this concerns you. So my understanding is that the interpreter is only needed for a witness, is that correct?
Yes, Judge, but just to let the court know, we did make a new offer to defense. They hadn't told me until just now that they were going to accept the offer.
All right, do the paperwork.
Yes, Judge. Okay, sorry.
All right. Martin Rios.
Judge. So it's gonna be the same issue on this one. We've got the witness we've had contact a few weeks ago. We did use the same phone numbers to attempt to contact them, but give us at that time. None of them would work.
Oh, we'll put it on the record.
Just letting you know, Judge.
Okay.
Your Honor, may I address the court?
Yes, we're gonna go on the record, but you can address the court. Okay. All right, the court is calling 2022 CR 10144, State of Texas versus Martin Rios. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Robert Featherston and Adam Pauls.
Are you Mr. Rios? All right, state, you filed a motion to dismiss. Why are you asking for dismissal?
Judge, so we were having difficulty initially contacting the complainant. About a month and a half ago, we were able to contact him, and which time he did give us new contact information to reach him. We've attempted several times to use all the information that we've had in order to reach out to him, and so far he has not returned any of our calls, text messages, voicemails, anything.
Okay. All right, defense.
Your Honor, if it pleases the court, we have filed a motion for speedy trial or in the alternative motion to dismiss for violation of a Sixth Amendment right to speedy trial. We'd like the court to hear that motion. I think the court should also be aware that the complainant in this case is on probation.
Okay. All right, and that cause number, the court is dismissing the case. And what I can tell you, Mr. Featherston, I don't know if it's true or not, but usually in this court, when cases are dismissed, they are dismissed. The state has no intention. State, do you have any intention of bringing this case back?
At this time, no, Judge, especially based off of the fact that the witness has had contact and then not or refused to reach out to us again. We have called him at this number. This is a number that he did answer previously. It's just now he's ignoring us.
All right, what I can tell you, defense, with regards to your motions in that case, the court has filed the dismissal.
Your Honor, if it pleases the court, I believe the record should reflect that the court signed the dismissal prior to hearing my argument about raising our Sixth Amendment right to a speedy trial. We are not waiving that right to a speedy trial. If the case does raise its head again, we fully intend on pursuing that issue. Additionally, Your Honor, Mr. Rios is also charged with a family violence case. We stand ready for trial in that case at this time. And we also have a speedy trial demand on that case.
All right, thank you. And the record will reflect that the court did sign the motion for dismissal, and just have a seat and we'll come back to your other case.
Thank you, Your Honor.
You're welcome. Can I see the following callers? Romero? All right, this is scheduled for trial.
Yes, Judge.
You ready?
Yes.
All right, so this will be up for trial today. So the jury's in the hallway. As soon as I finish with the plea on these cases, we'll start with jury selection. State, are you ready?
Yes, Judge.
How much time are you asking for, dear?
45 minutes, Judge.
I'll give each side 30.
I was about to ask for 30.
Okay. All right.
Thank you, Judge.
Oh, I'm sorry, Ms. Garza, is he going to the court for punishment if he were to be found guilty?
Let me check with Cornelius.
Okay, all right, thank you. All right, to the other people who are on the docket, I'm going to see where this case takes us. But the rest of you who are on the docket that's still pending, I'll see you all back here at 9:15. The attorney where are you coming from, sir?
Austin, Judge.
All right, so what we'll do is, Mr. Stevens, if you can be here at 9:15 a.m. and sir, you can appear by Zoom so that I can see where we are.
I was under the impression that if the murder case pled, that we were next.
No, you're not next because go to jail cases, and then it's whoever has been here the longest. And Ms. Garza's client is the next with the longest number of settings.
Do we have a consideration of our motions to suppress
I'm going to carry that with trial.
in both cases?
Yes.
And just so we'll know, what we're gonna be trying to.
If you will
Almost the
talk
eighth
to the
case.
state and see which one they're going to proceed on first. And usually it's the oldest case, but if you'll confer with them. And if there is no objection from either party, I do believe I have Mr. Stevens' cell number. So I'll be able to call him early enough to let you all know if something happens to this case.
We'll have time to get Mr. Barrett here, Your Honor.
Oh, yes. This would all be solved if they had light rail. Mr. Stevens, I'm putting you on that. To get us some light rail. It would be nice if it would take me at least from here to Dallas, then it would be a short drive for me to see my mom.
I'll put that second on my list, Your Honor. First on my list was to just ask the state to consider our arguments on this motion and that would dispose of both.
Oh, well, here's the thing. If you'll talk to them, I'm sure they will consider it.
It's contingent on the light.
We'll
rail.
keep trying then, Judge.
All right. Yeah, they're here to discuss with you.
Does Mr. Meyer have to be here in person, Judge? Can he appear also?
No, he'll have to be here in person. And again, counsel, if this case is actually continuing, then what I will do is you won't have to come down. But I'm going to call Mr. Stevens before the day is over. I just don't want you all waiting here. I'll call Mr. Stevens before the end of business day today to let him know whether or not you can just appear by Zoom and we'll give you a trial date. Okay?
Would you like to also leave my cell number with the clerk?
Yes.
Copy that.
Yes. And if you all can confer with the state and see if they've had a chance to review your motion.
Judge, we also have Adolph Lopez is from compliance. He's considered.
Oh, Adolph Lopez. Can I see the file on Adolph Lopez, please?
Judge, the state would just like to defer to you as far as the ruling on the motions.
Okay.
Who's the coordinator?
Hello, Mr. Lopez. How are you doing today? Thank you so much for your patience. I truly appreciate it.
Thank you very much.
All right. Ms. Abrams, does he need further evaluation? That's what I'm reading. Or am I missing something?
Judge, I think it was recommended at one point, EDRF,
Mhm.
diagnosis residential facility. Probation also had some other recommendations, but I do believe he was eligible for full diagnosis residential facility.
All right.
Your Honor, at the time where he was assessed for DDRF, he denied any drug use
Mhm.
prior to his arrest. So more than likely DDRF is not going to take him. We are recommending state ISF cognitive track for 90 days.
All right. So with cognitive track, but because it appears that there's some mental health issue, are we all in agreement that there are mental health diagnoses?
It's complicated, but he was, as I understand the procedural history, he was found incompetent and then restored or rehabilitated so that he could plea. And then after the plea, now we're here again.
But do we think ISF cognitive is a good fit for him?
Your Honor, based on the screen report from CH, the Center for Services, the diagnosis that was reported by Mr. Lopez was his being bipolar and having anxiety. He is approved for our mental health unit.
Well, the problem we have is DDRF is not going to accept him because he's saying he doesn't have a drug issue. So I honestly don't think ISF cognitive is what that needs to be. And honestly, I think Mick is not enough. So I don't know. And we can't refer him to mental health court because felony mental health court won't accept him because he has this is deferred.
It is deferred.
I know they don't accept anybody with pleas, but counsel, if you want to talk to Judge Ringel and explain him the situation of your client that he's in limbo, maybe he will accept him. And in the meantime, I'm going to call, if there's no objection, I'm going to call different facilities and see if there's some sort of placement for him. I just don't think ISF cognitive, because I think of more as ISF cognitive is people are not following certain rules and maybe they need an adjustment in their thinking. Like you need to report, you need to do this. I don't see it as a place for, I have mental health issues. And if I'm wrong in that assessment, let me know. Okay. All right, so let's do this. If you will talk to Judge Ringel, and then I'll see what other facilities I can find so that we can see for a placement for him. Because I know if I release him on Mick, what's going to end up happening, we're going to have the same issue that we have now. And who knows what end up happening, because we have your client speaking about the FBI, things happening under the bridge, that type of thing.
I understand. Your
All right, so how much time are you all thinking to bring it back?
I don't know when they have docket, but I can go see if I can schedule something to meet with Mr. or Judge Ron. And
So then what we'll do is we'll recall this for Thursday of next week. But sir, if they have information for me before Thursday of next week, we'll have you immediately put back on the docket, okay? All right, have you been taking your medications?
No, I'm not taking because I end up losing weight in the week and it's better for my bloodline.
All right, here's the thing about medications. I'm not a medical doctor, but I did have a lot of clients who would have mental health issues and they would stop taking their medication because of the side effects.
Yes.
And I always tell them, please just call your doctor and say, these are the side effects I'm having. Maybe they can put you on different medications, because if you go off your medication, you're going to become incompetent again. Then you're going to go back to the state hospital, however many months it takes for them to restore you to competency. Then you're going to come back here and they'll probably have you on the same medication if you don't let them know. You understand? Yes.
The last time, April 4th, when I came into court,
Mhm.
signed up. Well, recently, like I think a couple of days ago back, before today, I talked to Center for Healthcare. So they said they were gonna release me before today.
All right. Well, your attorney is going to be able to contact Center for Healthcare Services and see what we can do with placement.
And
And I know there are some new programs that Center for Healthcare Services has. And I want to say, I can't, the name of the person is escaping me now. I think her last name is Rios. They have some new stringent outpatient mental health things that they can do. So that's who I'll be checking with that in as well. So Norma, on Mr. Lopez, if we can recall him back for Thursday of next week. So we'll bring you back on August 10th. And again, if your attorney has information before then, all he has to do is come to court and let us know. We'll put it on the docket sooner, okay? All right? But be sure to let the people at the jail know that there's a side effect to your medication.
yeah, I'm not taking medication because I don't take medication as they prescribe me.
Okay. Counsel, can you let them know at the jail that he's saying he has some side effect from his medication? That's why he's no longer taking it?
I will know.
I was just waiting to get out.
Okay.
I got stuff to do.
All right, we're going to see what we can do, okay? All right, thank you so much.
Thank you, Your Honor.
You're welcome. Thank you so much. So Paulo Romero Everyone else who's up for trial, you need to be back here tomorrow at 9 a.m.
Yeah, just one more.
All right, if you'll do the paperwork.
Yes.
We're also happy to do it in the morning. Mr. Moreno, he's got to get his kids situated anyway.
All right, I tell you what, if you guys go over the paperwork, swear, have him sworn in, and then you all need to be, well,
He's just doing a misdemeanor.
when is his children? What time is it for his children?
Let me get a phone.
I just wanted to check with you. I know Martin. Is having bonds. On the docket papers, I don't know if coming back on that.
Yes, they're coming back tomorrow at 9:15, I mean at 9.
Okay,
I keep saying 9:15.
I just didn't know whether to stick around on that.
All right,
Thank you.
what is your child issue? Hi, oh, have a seat.
I have them right now with my older daughter, but I got to drop them off today at 8 o'clock at their mom's work.
Oh, at 8 p.m.?
Yes, ma'am. So I
Oh,
thought,
we'll be done before then.
well, but his plea is for a county time, Judge, on a misdemeanor. So I was anticipating you taking him in, and if you're not going to take him in until tomorrow, that's okay too. But
So you'll be turning yourself in tomorrow?
that's why I was wondering if you could run me tomorrow morning.
All right, do the paperwork, get sworn in, and then you need to be here tomorrow exactly at 9 a.m.
Yes, ma'am.
But do not leave until the paperwork is done.
Yes, ma'am. Judge.
Okay,
Thank you, ma'am.
You're
Have a blessed
welcome.
day.
hi, so how's it going? What's your name? Mhm. Oh, yes. So where are you at school? Yay, so you law student? Hey, after you finish the first year, everything else is just smooth sailing. But yes, so they're doing a jury trial in this case. It's a burglary of a habitation force. The range of punishment for this case is 2 to 20 years. I'm going to see if they're applying to the court for punishment if he were found guilty, or if they are applying to the jury. So a lot of times there are cases where people are charged and you may think they're eligible for probation from a jury, but I don't know, because I don't know all the facts of the case. I don't know if the person has been to prison before or not. So that's why I always ask the attorneys, is your client eligible for probation from the jury, from the court? Because they'll know. So the only time I know facts of cases usually is if somebody has done a bond reduction before me, because then people will turn in the police reports for me to review, or if there's been sort of like a motion to suppress. Jason, have you had a chance to confer with the state? I say with the state, you are the state, with them on Mark Stevens' motion? Just whenever. I know that's a motion that's coming up, and also Arlene Gang has filed a motion to quash her indictment on the stalking case. Yes. Yes, you are. Yes. Yeah, everything that did not work out today is coming back tomorrow. And so let the attorneys know they need to be here exactly at 9 a.m. And we'll start with jury trial at 9:30. No, you know what, for some reason, I don't know why this is with me, but when I was a prosecutor and defense attorney, and people would tell me, oh, Stephanie, your case is going to trial. And I would tell everybody, I don't hear trial music. You get to the point where you hear trial music. And then I was like, no, I don't hear trial music. One of my friends, who will not be named, Jamisa Jarman, she was new as a defense attorney. And she had this case with Judge Rahman, who's now a misdemeanor court judge, but she was a felony court judge. And so I tell her, I don't hear any trial music. Your case is not going to trial. She's like, yeah, it is going to trial. So I come to court. I'm wearing a skirt with a, what do you call it? From the 60s, where you have the sweat, not really camisole set. No, no. It's the top where you have the sweater and you have the sweater set, they go, a twin set. So I'm wearing a twin set with it. Jimmy says, you're not dressed appropriately for trial. I said, Jamisa, we're not going to trial. I said, I tell you what, if we're going to trial, I will find someone else to sit with you and I will just be in the audience taking notes. So you know what ends up happening? I find somebody to sit with her and I see her. And I said, so are you in trial? She says, okay, no, I'm not. So it gets to the point where you can actually feel the sound if something's going to trial or not. And sometimes people will say they want a trial, but then once there's a jury in the hallway, then they do not want a trial. Mhm. See? Yes. Yeah. Depends. So if he were to be found. Oh, thank you. Yes. Oh, yes, I was calling because I was wondering if you all were going to the judge and jury.
Oh, the cover sheet, yeah, it should be at the bottom.
What are we discussing? Just in general.
Got out
Okay.
there and like. Put numbers and stuff.
What the hell?
All right, y'all have,
Yeah.
here's the thing, y'all have 5 minutes. So that means y'all gonna be back here at 2:15.
Yeah, I want to go right.
Say, hey.
Okay.
I'm
my
about
office.
to
Do not
start
turn the
another
fan off in the other room.
I won't turn it off, but I understand that,
I'm
gonna turn it off.
No, no.
First year.
So, of course, since you've been working with the fourth court, you know, with a jury trial, both sides, based upon this case, they each get 10 strikes and they can strike for whatever they want to. And then and those are their preemptory strikes. And then their challenges for cause, it's just whatever the cause is, and they have as many challenges for cause to infinity, as long as it's something that's appropriate.
Well, I don't think I'm gonna be able to pull that.
And this is the probation officer.
This one, at least, you're gonna try it. And
Get an answer.
yeah.
This one we don't
Got it.
really how much students
Yeah,
sit.
just confirm with Rose who,
Like, we didn't know if we
or
were here
I
for
texted
work.
her just to say, hey, have the officers like requesting for tomorrow.
So in this case, he's decided to come to the court for punishment. So then there's not going to be any questions to this jury about the range of punishment because it's not their job to consider it. Now, what I can tell you is what it always shocks me doing voir dire. Each side always have a limited amount of time. Of course, if you're asking questions that are relevant and not questions that have already been asked, you can always ask for more times. And if a judge doesn't give you that extra time, it may come back on appeal. But I'm pretty generous with my time. I just ask people, how much time do you want for voir dire? And they'll tell me. So they were both agreed to 30 minutes. They said 45, but I always give people a little extra time. But since this is a burglary of habitation, 30 minutes, unless there's something strange about this case, is enough time for everybody. But I will always give my own introductory to all the jurors. You would be shocked, even though I do that, even though I talk about presumption of innocence or range of punishment, whatever it is, attorneys will go back and ask the same thing instead of, hey, maybe this is something I should be asking because the judge has done that, so I don't have to worry about that and I can move on to something else. Some trials that I had when the judge would ask everything, then what I would start doing is just do individual voir dire on everybody. And so in this court, the way we do it, thank you. The way we do it is general and specific are together. So people can use their time for whatever they want to use it for. I know some judges do it differently. Some people do
but-
general, then specific.
so-
Okay. But I found that takes much longer. So I just give people their time and they can ask whatever questions they want to ask.
I think you want that chair or this chair.
Oh, no. Each one is just different. So whenever you're brand new and never seen a jury trial in a specific court, you should just ask the judge or either ask the prosecutors. What I would always do is I would make sure that I get a chance to watch a jury trial in a specific judge's court. So then I can see what's going on. And I can say, this is the way they do it, or this is what they don't like, or this is how much time they give you. Some judges, when they say they're only giving you 30 minutes, guess what? They're only giving you 30 minutes. They're not giving you 30 minutes in 2 seconds or half a second, and they will cut you right off. So. No, it's not. And then some judges, when they say they're starting jury trial at a specific time, like today, we were supposed to start this jury trial at 1:30, but then everybody who's up for trial decided to plea. And normally I do not accept plea bargain agreements once your plea deadline date has expired. But if there's something in the police report or something that attorneys have discussed with me, probably off the record, then I will consider accepting the plea. For example, today we did a plea on a murder case, and murders are always hard because people think with murder cases, everybody should get a life sentence, right? Because somebody's dead. But I have to remind people, if that's the case, then we're doing eye for an eye type of thing. Not that you're killing the person who killed somebody, but you're giving them a life sentence. And not every murder case deserves a life sentence. You can think of different scenarios where somebody committed a murder where maybe they shouldn't get life, or maybe they should get 5 years. Before the law changed,
I'll move.
you could always you could try to get deferred for your client for murder. And of course, all the defense attorneys hated it when they did away with you applying for probation for a murder. Deputy Laura, is that somebody who left a cup over there? All right, Cornelius, we're gonna bring the jury in.
Okay.
All right. Just give us a moment. All right. So then sometimes what ends up happening is maybe there's some new information that the state has, some new information that defense have that they've never given to the state. Like right now, we're supposed to be doing a jury selection on this case. But obviously, I guess something has happened and I'm unaware of it. I'll be made aware of it if they're working something out. I don't know. So is anything worked out on this case or no? Okay. All right. All right. So if you'll sign the documents and we will hear it. All right. So you'll have your witnesses here on Wednesday?
Yes.
All right. So now what has happened is.
Yeah, see you after.
All right. So this is a student. So. So everybody is entitled, and he's from the fourth court. So some of this stuff I'm telling him, I know he already knows. So everybody is entitled to a jury trial. The state is entitled to a jury trial. The defense is entitled to a jury trial. So in this case, they're saying they want me to hear the evidence and they want to do a bench trial. So if the state were to say, well, no, we want a jury trial, then it would be a jury trial. So it wouldn't matter that Mr. Cox's and Ms. Garza's client wanted a jury trial because the state wouldn't agree to it. So in this case, they're saying they want to do a bench trial. They want me to hear it. So if I sign, now, mind you, I could say, no, I'm not going to hear it. But I know I don't do that. If people want a bench trial, I'll hear it. And honestly, I think it's a sign that everybody knows that I'll be fair. I always call a ball and a strike. So what will end up happening in this case is tomorrow we're going to come in and they're going to be here at 9:30. and everybody will have their witnesses and we'll proceed. So if you can have him sign the documents, and then I'll have the jury come in and we'll have a conversation with the jury so I can let them know they have just not been standing out there just to stand out there. So if you all could help the deputies by picking up the numbers that are in the chairs, that would be greatly appreciated.
Yes, in order.
Yes. There should be a document that we have.
There's one
Yes.
in there.
And so when a jury's been kept in the hallway, I always like to talk to them so they'll know that their time wasn't wasted. And I'll let them know what the process is. You can bring them in. What do you think? You want me to go outside? Whatever you want me to do. All right, so I'm gonna go outside and talk to the jurors because the deputies are telling me it's easier. All right, I'm gonna come outside. And one of the things I try to do where I can, I always said that if I had a staff or if I were somebody's supervisor, if possible, I would try to make their job as easy as possible. So if it's something that legally I can do, I will do it. So you want to come outside with me and meet the jurors? All right.
No, I'm talking to Norma. Thanks.
Okay, awesome. Hey, if you want to, you're welcome. And if you want to come down here tomorrow at 9 o'clock, even though we're going to start this trial at 9:30, you can see the other cases. Yeah.
And so it's the burglary, right?
Yes, we're going to go on this case. And if you want the cause number, you can look it up. I'll write it down for you. And it's public information. So I'll write down the name and cause number for you.
It's got my initials on it.
And guess what? When they call their witnesses, you can look at it and decide how you judge their credibility. Of course, you can't tell me because that would be my job, but you can sort of sit like a judge.
Yes, thank you so much.
All right, you're welcome anytime. All right, so we will be back here tomorrow for this trial at 9:30. Where are they? And we're going to put this on the record. Are you ready to go on the record? All right, you're going to go on the record on 2021 CR 5583, State of Texas versus Carlos Romero. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense? And are you Mr. Romero? Come up, please. Are you Mr. Romero? All right, Mr. Romero, this case was scheduled for jury trial. We actually had a jury in the hallway. You understand that? That's either yes or no. And you understand you have a right to jury trial? All right, and my understanding from your counsel and from the state is that you wish to proceed with a bench trial and not a jury trial. Is that correct? Right. And I'm going to show you the document entitled Jury Waiver Trial Before the Court. Did you review that with your attorneys? Did you understand it? And did you sign it? All right, anything else from either side?
No, Judge.
All right, so we're going to be back here tomorrow at 9 a.m. Just, no, 9 a.m. if you all have any motions that I need to hear beforehand. But the actual trial, bench trial for this case will start at 9:30. All right. All right, is there anything else?
No.
All right. Norma, can you just give them a reset form? And then Deputy Laura, I guess we will do our book club on Thursday. Oh, sorry. My dates are just all off today. Maybe Friday. Are we doing it?
This Friday.
Is it? Yeah, it's this Friday. Have you finished the book?
Like a little while. I could be. Oh, I could be done.
Yes. Bye-bye. Okay.
Once you get that halfway mark, it's like, yeah. Don't let her stay.
Yes. Don't let her stay.
At all. So, who's the author?
Nicholas Sanders.
Don't let her stay. Get out.
I reached out to her on Facebook. She responded.
Oh, she did?
Yes.
What did she?
Was that by?
Oh, I'll have to pull it up on my phone.
Was that by Orange Juice Jones?
But it's an awesome book. So we have a Bridget, we now have a 187th book club. And so our first book that we just happened upon was Don't Let Her Stay.
See how you figure, right?
Now.